talking about the Trump immunity case from the last Supreme Court term. So I'll get us started. I'll introduce them both, and then I'll turn it over to them. So Professor Robert Luther serves as a distinguished professor of law here at our law school, where he teaches and writes on federal courts, legal and judicial ethics, political law, Congress, and professional sports. He's also the founder of Constitutional Solutions, PLC,
awesome.
Which navigates judicial candidates, judges, elected officials, professional athletes, and executives through high-stakes hearings, investigations, and reputational attacks. Immediately prior to joining the faculty here, he spent over 5 years in the Washington, D.C. office of Jones Day, where his practice focused on strategic counseling, crisis management, and litigation. Prior to joining Jones Day, he served as associate counsel to the President of the United States in the White House counsel's office. In 2018, New York Times Magazine referred to his work on judicial selection as unique in White House history.
It's true.
House,
They undersold it, actually.
Yes. He supervised the successful U.S. Senate confirmation hearing preparation of over 150 federal judicial nominees. Before joining the White House, Professor Luther served as counsel to then U.S. Senator Jeff Sessions on the U.S. Senate Judiciary Committee. He served as a core member of his Attorney General confirmation hearing preparation team. He was also a law clerk to Judge Daniel A. Mannion on the United States Court of Appeals for the Seventh Circuit. Earlier in his career, Rob practiced civil and appellate litigation at a boutique firm in Williamsburg, Virginia, and taught at William and Mary Law School. He frequently speaks on the legal profession, political law, and federal judicial selection, and his scholarship is published in the law journals of nearly 20 universities, including Harvard, Georgetown, and Texas. He holds active law licenses in Virginia and D.C., and serves on the advisory board of the Wilson Center for Leadership at Hampton-Sydney College. Since 2019, over 120 of his former students have secured clerkships with federal judges, including me, and I'm sure a number of other.
You guys are very lucky, by the way.
Here. And now to introduce Professor Blackman. Professor Blackman is a national thought leader.
And alum of which law school?
And an alumnus of this law school.
Thank you.
2009.
You weren't even born yet. Mostly true.
Professor Blackman is a national thought leader on constitutional law in the United States Supreme Court. His work was quoted during 2 presidential impeachment trials. He testified before Congress, and he has testified before Congress and advises federal and state lawmakers. He regularly appears on television, including NBC, CBS, ABC, Fox, the BBC. He's also a frequent guest on NPR and other syndicated radio programs. He's published commentaries in the New York Times, the Wall Street Journal, the Washington Post, and other leading national publications. Since 2012, Professor Blackman has served as a professor at the South Texas College of Law in Houston, where he holds the Centennial Chair of Constitutional Law. He's also an adjunct scholar at the Cato Institute. He's authored 3 books, and his latest, An Introduction to Constitutional Law, was
Who has a copy? No one? Bernstein doesn't sign it anymore?
Was a top 5 bestseller on Amazon. Maybe thanks to Professor Bernstein.
Yes.
Professor Blackman has written more than 5 dozen law review articles that have been cited collectively nearly 1,000 times. He is president of the Harlan Institute and also founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league.
Launched it here.
He blogs at The Golak Conspiracy, and you can also follow him on Twitter.
Thank you so much.
We're very excited.
Thank you.
Obviously, as you can tell from their CVs, both of these professors are very qualified to weigh in on the Trump immunity question. We're very excited to hear your thoughts. So with that, I'll turn it over to you.
Thank you so much. I gotta tell you, you don't know how lucky you are to be at Scalia Law. Am I right, Rob?
That's how I feel.
I went here from 2006 to 2009 before it was even called Scalia Law. Scalia was still alive and well at the time. The faculty you have here is unlike anyone else in the world. You will not get an education like this anywhere else. You're exposed to opportunities in government that you will not get anywhere else. Rob's clerkship program is unrivaled. I mean, the number of people who get clerkships here far surpasses the rankings by orders of magnitude. So you are all doing remarkable. And I have very fond memories. I took contracts in this room as a 1L. I took Civ Pro in this room, so it's always very fun to come back here. The topic today is Trump, the United States, and immunity. And this is a topic that I think has given a lot of attention recently, but frankly, in a couple of years, this case won't be talked about very much. I think it's sort of a flash in the pan, it blew up, and it's going to fade. And what I'd like to do today is put the case in some context of really why it's not as big of a deal as you might think. And even if you think the case is wrong, there are a lot of cases that are wrong, this doesn't rank some of the worst cases even in the last decade. So let's talk about immunity for a bit. Let's put aside presidential immunity. So, sir, I see your sticker on your lap that says Anti-Qualified Immunity Club. You don't like QI, do you?
No.
Tell us what is QI, Qualified Immunity?
Generally, government actors, mostly police officers, not being able to having immunity from suits for certain.
Is there a basis in the Constitution for qualified immunity?
No.
Is it kind of just made up?
Believe
It's
it or
been
not.
around for a long time, hasn't it been?
Yeah.
So believe it or not, we have immunity doctrines that are made up, and they're around for a very long time. And they protect not just the president, they protect every law enforcement agent in the country. Am I right about that, sir? Right, so immunity has been around for a long time. And these doctrines, we're all originalists here, Justice Kagan would say, they're not well grounded in text and history. So we have qualified immunity. Who knows about absolute immunity? Any prosecutors here? Any people working in the DA's office? Yeah? Guess what? If you're a DA, you don't have qualified immunity, you have absolute immunity. Good luck suing any prosecutor for anything. The suit of malicious prosecution exists in theory, but they're very, very hard to break. So if a prosecutor ruins your life, throws you in jail, says, oh, you know that evidence, we got to suppress it, it wasn't obtained. Okay, good luck suing them, you can't. Want to know who else has immunity? Judges. You cannot sue a judge for nearly anything. You know, maybe sexual harassment, if you're a law clerk, that comes up now and then. But for the most part, you cannot sue a judge because they have absolute immunity. Why do I start here? There's been so much outrage about granting immunity to the only person in the Constitution who has power, right? There's one person in the Constitution who has power, it's the president. Everyone else kind of diffuses their power. To give immunity to that one person seemed like the end of the republic. It's simply, I think, an overstatement. Let's do some history here, or George Mason, we always talk about history. United States against Aaron Burr, a trial that actually happened here in Virginia, actually over in the South in Richmond. Aaron Burr, as you know, rose to fame. He shot Alexander Hamilton. He was also the U.S. Vice President. He was disputed in the election of 1800. But after he became Vice President, he started getting involved in foreign intrigues. The exact nature wasn't sure. There were allegations that he was trying to raise up an army to take arms against the United States, or maybe he was just trying to acquire some land in Florida. It's actually very vague. To this day, we don't even know what his machinations were. But for whatever reason, the U.S. government indicted Burr on charges of treason. Treason for the vice president. The trial was held in federal court in Virginia and was presided by none other than Chief Justice John Marshall. This was a very early case from, I think it was 1803 or 4, might be off by a couple of years. During the trial, Burr said, I need evidence. I need evidence that will show that I'm free. He requested a document sent by a general to President Thomas Jefferson. He says, this document of evidence shows that I am not guilty. And as you all know, even under the Constitution, if there's evidence, people have to produce the evidence to show you're innocent. This is even before Brady or anything else. You can request evidence that shows you're innocent. You can always have that. So under the Constitution, it's a compulsory process. Thomas Jefferson basically said, yeah, no way. I'm not giving you a damn thing. So there was this back and forth between Burr, the defendant, Marshall, the judge, and the Jefferson administration. And eventually, Aaron Burr got kind of what he wanted. And Marshall issued an opinion saying, okay, Mr. President, please produce this document. Please honor this subpoena. It wasn't exactly an order, but it's saying you should produce it. What did Jefferson do? He produced a redacted form of the document. Not like we didn't have PDF black lines. He basically made a copy of the document with words omitted. Because he said, what we would today call classifications. Didn't exist then, but these were secrets of the state he did not want to disclose. So as you know, when you get an order from a court to say, deliver a document, and you deliver part of a document, have you complied with the court's order? No, you have not. That's called contempt of court, right, Rob? You're a former White House lawyer. If they say, produce this document, and you omit words that are pretty important, that's called contempt of court. Did Marshall ever hold Jefferson in contempt? Of course he didn't. It kind of just went away. Eventually, the charges were dropped. It was a very weird case. But a lot of people look to this evidence as an incident that, aha, the courts can issue subpoenas to the president. If you actually look what Jefferson returned, he didn't honor the subpoena. This is one of the founding moments in which immunity was sort of developed. The idea that the judicial process, whatever it is, does not extend in the full regards to the president. That he has some sort of immunity, some sort of protection from a subpoena that a private citizen would not. Okay? So that's the first historical incident I want to talk about. The second one, jump ahead to 1972 and 73, involving President Richard Nixon. Now, this is a president that's always seems to be in the news, no matter how far we get from Watergate. Everything's Watergate, Sexgate, Benghazi Gate, everything was a gate. But this is the original Watergate. On June 17th, 1972, some men broke into the Watergate Hotel only a few miles from here, and they stole some stuff. Now, what they were actually looking for, to this day, we don't really know. To this day, we are actually not sure. And what we also don't know is, did President Nixon know about the break-in before it happened? We don't know. Despite everything we've learned about it, we actually are not sure. Nixon learned about it afterwards, though. That much is clear. Why? Because we have recordings of the White House tapes. And President Nixon took certain efforts to, shall we say, cover up the break-in. And he didn't want this to come back to his administration and to make himself look bad. This is what politicians often do. They say, okay, make this thing go away. But when you're president, you can fire people, you can tell prosecutors not to prosecute, you have other leverage. The case of U.S. versus Nixon wasn't actually a criminal prosecution against Nixon. Nixon was never indicted. He wasn't. There was a government opinion saying you can't indict the sitting president. What happened was some of Nixon's subordinates were charged with a crime. And the defendants demanded the White House tapes. They said, we need this as evidence to exculpate us, right, to help our criminal defense. And the Supreme Court then had to litigate this issue. Could the special prosecutors and Leon Jaworski demand these tapes from the president? Initially, Nixon said, who the hell are you? You work for me. You're an executive branch lawyer. You can't go to court to seek a remedy. Your remedy lies in the executive branch. I'm not giving it to you. So the court actually held a decision that I think is almost certainly wrong, that an executive branch lawyer can sue the president for a subpoena. I think that's under any version of standing, we have to say that can't be right. This is an internal dispute. But it was the 70s, whatever, everything went back then, right? This was the same year's row, right? Whatever, it's law, it doesn't matter, right? Trimester, immunity, whatever, make it up. But what's important is the immunity issue. They said, okay, fine, the special prosecutor can sue the president to seek a subpoena, but Nixon cannot raise immunity here. Why? Because there's a criminal defendant who needs this evidence, and the right to produce evidence prevails over whatever immunity the president has. Now, I think that was probably a wrong decision. I think it misreads the Aaron Burr precedent, but again, it was the 70s. Anything went back then, all right? Fast forward about 10 years to Nixon v. Fitzgerald. Again, this is another Richard Nixon case. At this point, he's long out of office. But while Nixon was president, he made some disparaging comments about a person named Fitzgerald. He said some bad things about him. He was an employee of the Air Force, as I recall. And years later, Fitzgerald brought a lawsuit to the former president. Civil, not criminal, civil. And the lawsuit saw some damages. Former President Nixon said, no, you can't sue me. My actions while president, my official actions, are governed by not qualified immunity, absolute immunity, the immunity that federal judges and prosecutors receive every day. And the Supreme Court more or less agreed with Nixon. This was the Burr court in the early 80s, when things kind of calmed down a bit. And the court said the president is entitled to absolute immunity from damages predicated on his official acts. Absolute immunity. That's a very high burden. And the court also said the president's absolute immunity extends to all acts within the outer perimeter of the duties of his office. So it's not just his core powers, if you're in the perimeter of those core powers, the curtilage, if you will, for those who take Crim Pro, if you're in the perimeter of his powers, those are also entitled to absolute immunity. And just to be very clear, what does absolute immunity mean? That doesn't mean you go to trial and you plead a defense and say, you can't have this charge. This means you didn't even go to trial. You dismiss the charges, effective in a motion to dismiss at the early stage. Critically, with immunity, you have interlocutory appeals. Because usually if you raise a defense at a 12b6 and you lose, okay, you have to go to trial, right, or some summary judgment. But with an immunity issue, you go up right away. That's why the Supreme Court heard the Trump immunity case so quickly, because you do interlocutory appeals. This actually will matter when we get to the Trump case. All right. Next case, which I think maybe some of you are alive for, Clinton versus Jones. No, I'm dating myself. So this involved President Clinton, and he had his problems. One of them involved Paula Jones. Before he was president, he was the governor of the state of Arkansas, and he was alleged to have committed some sort of sexual conduct during Ms. Jones. Let's leave it there for now. While Clinton was in office, she brought a civil lawsuit. And the question in Clinton v. Jones was, can the sitting president be sued for civil damages from his pre-office conduct, that's before he came to office? The court, in opinion by Justice Stevens, said yes, he can be sued, that there's no immunity for action before you're in the office. And Stevens said, my favorite line, there's really no history of people suing the sitting president. We have to worry about this, right? This is not going to be a problem. Donald Trump said, hold my beer. So as soon as Trump came to office, he was being sued every 5 minutes, Rob. Is that about accurate?
There were a lot of lawsuits.
There were a lot of lawsuits. So Stevens' prediction didn't even make it a decade and a half, right? It was just wrong. Trump was sued for emoluments. He was sued for defamation. He was sued for, I lost count. But he was basically being sued nonstop. And Rob's a White House lawyer. This does take a toll on the president's ability to manage the country. There is a cost to these lawsuits in addition to the lawyers, but it's a 24/7 job you have to do, and there is a cost having all these, I didn't say frivolous, I didn't say that, all these lawsuits being brought one after the other, and there's also an incentive to weaken the president because if you have a lawsuit, you get discovery. You get to depose the president, right? Often the discovery is the end game. Winning is actually not important. It's the process that matters. So we had the emoluments litigation. We had litigation on Trump's tax returns that seemed to go on forever. You had a subpoena from the New York DA for his tax returns. You had a subpoena from the Senate for his tax returns, right? So you had nonstop civil litigation. But there's also criminal litigation involved. And this involves the Mueller investigation. So as you remember, James Comey was the director of the FBI. And shortly into the Trump administration, Trump fires Comey. Now, everyone agrees the president has absolute power to fire an FBI director. It's not protected by tenure. It's not like, for cause. You can fire him at will. But at the time, Comey was leading an investigation to Russia. Russia, right? Russia. And the charge was that Trump firing Comey itself constituted obstruction of justice, which is, usually for most people, let's say there's a prosecutor, you beat up the prosecutor to make him, you can't investigate you, that's obstruction. But when the president, you don't have to beat him, you just fire the guy. Trump said, wait a minute, I have the power to fire this person. That's more important than any sort of obstruction charge. But for nearly 2 years, and it occupied our lives in such a way, Mueller was investigating Trump, investigating everyone around him, and he wrote this book-length report, which I'm sure all of you read from cover to cover, about Trump. And what's weird is he stopped short of indicting Trump. He says, well, we can't indict Trump, but he sort of hints, I would if I could, right? If I was able to indict the president, I would. He doesn't quite say that. It's this very weird dance. And he testified before Congress. It was a very weird hearing. I think his best years behind him. I'll just put it there, right? It was not his best performance. I think his staff wrote the report, and he was just kind of a figurehead at that point. But that's where things left. After Trump left office, the Mueller reports have wound down. All this to say is that the case law here is such that the president has this absolute civil immunity. Some subpoenas can be served against him, and he has produced evidence. Enter January 6th. After January 6th, Merrick Garland comes to office, and his first order of business is to indict Trump. No, he doesn't do that. He waits nearly 2 years to appoint a special counsel, who then takes even more time to indict Trump. By the way, if they had indicted him on January 21st, this all would be done. We wouldn't be worrying about this now. They took a lot of time, and this robust conspiracy, which doesn't add much to what we knew 2 years ago. But eventually, Jack Smith, the special counsel, indicts Trump in 2 places. He indicts him in Florida. This is the Mar-a-Lago documents case. I'm actually involved in litigation there. I have an amicus brief. But this is saying that Trump, after he left office, held on to these presidential records, and he failed to provide them to the government, and there's all these various charges. The Florida litigation also questions whether Jack Smith was appointed properly. If you want, I can talk about that during Q&A. But the main event is the DC show. This is all the J6 stuff. And Trump was not charged with insurrection. He was not known to be charged with insurrection. Instead, it's obstruction of official proceedings. It's kind of nebulous charge that Trump's actions prevented the vote count. Just that's the gravamen of the charge. But Trump raised immunity. He said, look, I have absolute immunity from criminal prosecution, right? For my core presidential duties, the exact same thing. And I think all the conduct are at least related to his core duties. Even Trump said, I instructed Mike Pence to do this and this. He's my vice president. I can talk to him. The trial court rejected it. The trial court said, no, there's no such immunity. The DC Circuit took a long time to resolve this. People got very upset with them. And eventually this long opinion didn't matter because the Supreme Court decided it anyway. And the DC Circuit said, yeah, no immunity here. And it goes to the Supreme Court. Now, what's important to recognize here? No one asked to overrule Nixon v. Fitzgerald. Again, which established absolute civil immunity. No one asked us to do this. And the court made one very important move, which is more of a burden on the president. Civil litigation or a criminal prosecution. In my mind, that's an easy question. Criminal. Why? With civil, you can settle it. You can make that go away, hush, hush, hush. Paul Jones never went to trial. Bill Clinton paid her off. He settled it, right? But with criminal, you can negotiate a plea bargain that means you're going to jail, right? You can't settle a criminal case the same way you could a civil case. And the risk of a monetary judgment, which at worst maybe yields bankruptcy, versus jail time is far different. And what the court, I think at least 5 of the members of the court, maybe 6, recognizes, whatever the rule is for civil, we should have the same rule for criminal. And I've been saying that for years, and people thought it was crazy. No, civil's different, criminal's different. Whatever the rules for civil should be for criminal. Okay. So the court rules for Trump, and the vote is 6-3-ish. Why did I say ish? Because Justice Barrett, usually Rob likes her, I'll be nice. Usually Justice Barrett's a very clear writer. She's usually very direct and to the point, except when she doesn't want to be to the point. There are some opinions where I have no idea what Barrett's saying, and I think it's deliberate, or at least she doesn't want to clearly spell out her thinking. But usually she's very precise. The vote was 6-3, and Barrett said, I don't agree with these parts of the majority. She doesn't really tell us what she agrees with. But let's do the majority first, make it easier. Chief Justice Roberts wrote the majority opinion. Roberts, for all of his warts, was an executive branch lawyer. He understands this case intrinsically. And for his perspective, the biggest risk was not having these rogue presidents, but having these presidents chilled in their actions for fear of future prosecutions. He was worried that a president think, man, do I send this drone strike? Oh wow, do I launch this bombing run of this country? He's going to be worried not by what's in the best interest of the republic, but is my successor going to indict me? That's a legitimate concern. So who was in the executive branch? Roberts, White House lawyer. Clarence Thomas, EEOC head. He understands how the agencies operate. Sam Alito, DOJ, SG, right? Neil Gorsuch, executive branch. Brett Kavanaugh, White House secretary. These were all people who worked in the executive branch. They understand how these things work. Amy Coney Barrett, 0 executive branch experience. I think that explains the difference. She was an academic like me. We can criticize academics all you want, but she just hadn't had that experience. The majority, John Roberts, he loves Robert Jackson, by the way. The majority is just kind of this 3-tier approach, almost like the Youngstown framework. He says, so I'll just read it. He says, first, at least with respect to the president's core powers, absolute immunity. So if it's in the core, you cannot prosecute it. Whatever statute Congress enacts is a mere statute. Under the Supremacy Clause, the Constitution is above a statute. So Article 2 trumps, no pun intended, any statute passed by Congress. So if you have an obstruction statute, whatever, that's great, good for you, right? But the president's powers are on top, core. I don't think any of the 9 justices disagree on this point. I think even if you put Ketanji Brown Jackson into a lie detector, she'd agree with this part, right? I think everyone agrees that if it's core powers, you can't criminalize, if the president signs a bill, right, and then the successor indicts him saying, that's a crime, okay, that's not going to fly. Okay, then you have the third tier towards the bottom, and I think actually all 9 justices agree with this. Even Sam Alito and some truth here would agree with this one, right? He says, for private acts or unofficial acts, there's no immunity. This is if Trump just walks on Fifth Avenue and shoots someone. I don't think even anyone would say, okay, that's presidential immunity. Okay, but then it's the middle one, much like in Youngstown, that creates the biggest controversy. So Roberts says, for other official actions that are outside the core constitutional powers, there is presumptive immunity. That's the key. If it's in the middle, outside the core, but in the periphery, it's presumptively immune. Unless the government, as the prosecutor can show, that applying criminal prohibition would pose no danger to the intrusion of the executive branch. In other words, the government must show why prosecuting this activity would not burden the executive. It's the burden of the prosecutor, not the president's burden. So I don't think this is such a crazy test. I think it actually tracks Youngstown more or less, but at least it gives some teeth to Nixon v. Fitzgerald, which no one asked to be overruled. Justice Barrett had a dissent, which again, I like Justice Barrett, but sometimes she frustrates me. This is one of the frustrating ones, where she doesn't really tell us which part she agrees with the majority. She says, I don't agree with one part in particular, maybe 2 parts. This was about evidence. So let's say that there's some conduct that is immune. Could you still introduce as evidence in a trial to make some other claims? Roberts says, no way. If it's immune, you can't even introduce as evidence. That would have a chilling effect on the executive. Barrett says, oh no, rule, was it 403? Rules of evidence, just balance it out. Someone's different, a trial lawyer. Yeah, let the trial judge handle it. I think it's a problem. And if you don't believe me, look at Jack Smith's 200-page report released last week, which is effectively the evidentiary record. You put out all the dirty laundry without the benefit of a trial that you can respond to. I think it's actually very problematic. All right. Beyond that, Barrett doesn't really say she agrees with the majority on immunity. She's very much disturbed by the idea of the interlocutory appeal. That actually bothers her. She says, well, what's the big deal? Why can't you just go to trial and appeal after the trial? Why do you need interlocutory appeal? Again, the trial itself is where all this stuff is being aired in the court of public opinion. That is a chilling factor, even if there's no conviction. Again, I think she's wrong on this, and the Jack Smith reporting proves this. There were 3 dissents, and I think the dissents were very alarmist. There was Justice Jackson, Justice Sotomayor, and Justice Kagan, and they try to say this is the end of the rule of law, that the president's above the law, and so and so. I think the Roberts opinion left open a lot of stuff Trump will be prosecuted for. In fact, the Jack Smith indictment 2.0, I don't agree with all regards, and a lot of it will probably get past the immunity hurdle. So Trump can be charged. And by the way, if Jack Smith had originally brought a more narrow indictment, we would not be here. He decided to bring in the entire executive branch with Jeff Clark and all these other people. He didn't have to do all that other stuff. All he needed was to get Trump from one charge very narrowly, and it'll have the same effect as his blunderbuss indictment. So I think there's actually an overcharging problem here as well. But I think the sort of this outrage, I think will be eclipsed over time, because people realize, okay, it's going to be very rare that the president will be charged with a crime. January 6th was sui generis in every way possible. A lot of people went to jail for it. Actually, might be pardoned in a few months, we'll see. But this was a bit of a reach. The case sort of is ongoing. Jackson is trying to prosecute him. There will not be a trial before the election. That's impossible at this juncture. We saw this this brief that was put on the record by Judge Chutkin about a week or 2 ago. And I think in hindsight, we just won't talk about this case much more. I don't think maybe of David Bernstein, I'm not putting this in a case book. I mean, there's just really, maybe a short excerpt. It's just not that significant. All right, that's all I got. I welcome my good friend Rob's thoughts and have your questions later. Thank you.
No, I was going to clap.
Please clap.
I don't know if can you hear me? I don't know if I need that. Well, thank you, Josh. That was really interesting. I learned a lot, as I often do when I listen to you or read from you. I had a couple questions, and I guess I could start by giving my general comments on the opinion. I enjoyed the opinion. I thought it was well written. You know, the chief definitely knows what he's talking about when he's talking about the role of the White House lawyer and the importance of immunity to the president so that he can execute his official responsibilities. I thought there was one area that was a little weak, though, and maybe we'll just start talking about that one. And it was the section on presumptive immunity. I guess we would call it the second tier in the Justice Jackson sort of analog framework here, where he talks about the relationship between the president and the vice president with respect to the conduct on January 6th. So, we learn at the beginning of the opinion that the president has absolute immunity for his communications with the Attorney General, official responsibilities, absolute immunity. But why is the vice president, the person, his closest political analog, the only other person elected to represent the entire country, the second in command, why would he not have the same level of protection with respect to communications with that individual that he would for the Attorney General, who's confirmed by the Senate but not elected by the people? It seems to me that sending this case back on remand for further fact development on January 6th, when everyone knows what happened, it's in the opinion, it's in a million press reports, 900 people were interviewed by the January 6th committee. There's really no question as to the facts. So two questions. Why isn't the VP entitled to the highest form of protection in communication with the president? And why was this sent back when we all know what happened?
So this is one of these issues that has been lingering for a very long time. Which branch of government does the vice president belong to? Right? If you go back to the Constitutional Convention, the vice president was added very, very late in the game. Well, I think it was already in September of the convention, the last couple weeks. And the reason why the VP was added was basically who's going to step in if the president dies? So the vice president. And what powers can we assign to the vice president? And they kind of just said, okay, we'll give him president of the Senate. And if the Senate ties, he can tie break. And also we have this electoral college process. The president, the VP, will preside over this joint session of Congress of both houses. That's really all the president, the VP has. The president, he doesn't do anything else. He has very few powers. John Adams said it was the most worthless position ever created. He's probably right about that. But Rob is correct that it's the president's closest political ally, second in command if he ever has to step down, and also a political confidant in many cases. The difficulty for the court, though, was does the president have any power over the VP? Can the president order the VP to do this or that? Not in the same way as the Attorney General. Specifically, on the joint session of Congress, the president has no power over that session. All the power resides in the vice president. So if, the vice president gave an order, or the president gave the vice president an order saying, do this, you can follow it, or you say you have no power to give that order. Usually the president gives you a lawful order, and you say, no, you have to resign. That's the rule, or you get fired. The president can't fire the VP. There's no mechanism for that. And I really think it's a lawful order to tell him what to do. The challenge, though, we got pizza?
We got extra.
Oh, this is my man right here. Everyone gets a slice. The challenge on January 6th is there was such a blurring of the roles between Mike Pence as VP and Mike Pence as President of the Senate. Those roles were blurred lines. Those lines were very blurry. And I don't know that further fact-finding will bring any more clarity to what we already know. Rob's like, with 1,000 witnesses, we know everything that happened. Mike Pence testified for a grand jury. We know what happened. I think what happened is, and Rob can maybe back me up, that's why also the other Rob in the back of the room, sometimes when you're holding 5, you have to make some compromises. And I wonder if maybe Kavanaugh, or maybe even Barrett, at a time, was saying, okay, we're not sure about the VP. Let's just hold this one. Let's not look at giving Trump a full victory. I don't think Gorsuch would have done that. So maybe it was Kavanaugh or Barrett. You don't know how the salami's made. I mean, there actually has been some good reporting how apparently Roberts didn't want to talk to the liberals about making a 9-0 decision. He was going for 6-3, but he had to hold his 6, and I think he barely held Barrett. By the way, do you know who actually pays the vice president's salary? It comes out of the Senate's budget. And the vice president's staff actually pay from the Senate's budget. So this is not a frivolous question for which branch of government pays for the VP. There's actually a long saying debate about this, but it's unsatisfying, which makes you think there's like sort of a deal. They just had to sort of split the baby.
So when I think about the executive potentially bullying the vice president, I think about Watergate, and we all know what happened then. Folks resigned.
Yeah.
What do you think would have happened if, I mean, I guess why didn't Pence resign, and if he was being bullied, which I have some
I
doubts
mean,
about. But,
it's sort of, this is actually a really good question. Usually when a person resigns, there's someone to step into his place. Right? If the Attorney General resigns, there's Deputy Attorney General. If he resigns, the Associate Attorney General. If he resigns, Solicitor General, right? There's a line of succession. If the VP resigns,
Speaker?
no, that position remains vacant. You have to confirm a new vice president, with both houses confirming it, which will never happen in our modern era. So the VP remains vacant. Now, during the joint session of Congress, you could have the Senate President Pro Tem preside. Who was it? Was it Leahy then in 2020?
No, I think Leahy had retired at that point.
Was it Patty Murray maybe? Was it Feinstein?
Probably was, may have been Feinstein.
Was it Feinstein or Patty Murray? I can't remember. But anyway, Mike Pence, I've never asked him. I met him once in an elevator. But I've never asked him. Many years ago. He might have decided that if he were to resign, it would create even more chaos, having a Democrat preside over that joint session. So perhaps he thought it was better for him to stay in office. It's a weird thing with the vice president. Again, usually in any other office in government, if you resign, there's someone to step in place. But when you're a principal, when you're the apex official, there is no backup. And he decided to stick it out. Yeah, I can talk about Mike Pence for hours. Maybe you can too. But I don't know that he had a choice. I mean, he had a choice. He could resign, but I don't think he needed to because I don't think there was a lawful command being made. Bullying's like, so what? You get tough skin.
I hate to fixate on the vice president, but
Sure.
it seems to me that that's the most interesting part of the opinion. This one quote, the government explained in oral argument that although it has not yet had to come to grips with how it would analyze the interaction with vice president, there is support to characterize it as official. Can you explain why DOJ pursued this case without having a theory on the president's relationship with the vice president? That seems to be sort of essential to the disposition of the whole case.
Yeah, so just to be very clear, this is a case brought by a man named Jack Smith. In my view, he's a private citizen with no governmental power, right? He doesn't really work for Merrick Garland. I litigated this case in Florida. I think the Appointments Clause issue is valid. But during the hearing in Florida, Judge Cannon asked the counsel for Smith, did Jack Smith seek permission from Merrick Garland before he indicted Trump? The lawyer refused to answer the question. So you have this lawyer who's arguing about the United States, indicting the former president without even asking the AG. So you ask me, why don't they have a theory? This isn't the sort of prosecution DOJ would ever bring, because it raises so many thorny questions about how the executive branch works. When you have this outside prosecutor who's quasi-independent, who doesn't really care about the vice president, he cares about getting a conviction in this case. I mean, Justice Scalia's statute stands looming over us all. His dissent in Morrison v. Olson from 1988 was correct. He says when you have a prosecutor who has only one target, right, only one defendant to go after, he'll fall into the end of the earth, like Inspector Javert from Les Mis, if you've ever seen the musical or read the book. They didn't need to bring this case. Everyone knows what happened on January 6th. We've learned almost nothing from this entire process, almost nothing. I mean, maybe a few things here and there about what Trump said in the limousine driver to a Secret Service agent. I mean, frankly, okay, fine, we learned some new things. But when you have a special prosecutor whose job is to prosecute Trump, he will. If you have an accountable prosecutor, you might say, you know what, in the interest of the country, how about I just write a report, right? Release a report on what happened on J6 and let the people decide. But that was not the decision that was made. Garland said, by the way, Biden was leaning on Garland to appoint a special counsel. All this stuff, oh, Trump will prosecute his enemies if he's in office. Hello? Biden said, appoint a special counsel to prosecute Trump, and Garland did it. It's the same thing. It's like living in a bizarre world. This man is under indictment in several courts. Like, oh, Trump will prosecute his enemies. Come on, right? But there was no theory. Jack Smith has taken positions at odds with long-standing DOJ positions on a lot of things. By the way, there's a policy. You don't bring criminal charges within 60 days of election, and he keeps bringing new indictments. Look at Jack Goldsmith in the New York Times today. He didn't have to re-indict Trump now. The statute of limitations would not have run. He could wait till November 5th or November 9th, whatever the day after the election. He re-indicted him 2 weeks before the election. He didn't have to, right? He didn't have to put the report before the election. There's nothing that requires this to happen, but he did it. I didn't answer your question, but that's my answer.
No, I think you did answer the question. You made the point that I think is important for people to understand that the special counsel's interests should be aligned with long-standing Department of Justice policy because he's ostensibly acting on behalf of the Department of Justice. But we see in this case, we see by this representation in and of itself that those interests are not aligned here.
No.
Because institutional DOJ would never file a brief without taking a position on a central core matter of the case like this, especially one of this kind of significance. So I think that supports your point. I think the argument itself supports your point. Is it time to take some questions?
Happy to hear some questions from the students. You'll be able to ask about
You
Erie.
get some
I learned Erie in this room. I remember I'm so scarred by it. Erie was wrong, by the way. Yeah.
Just on the last point, do you think, like, given how the special prosecutor's been used and going back and forth, how it's clearly weaponized, do you think we could get 5 justices to say enough is enough? Scalia was right. This is a principal officer, and then you could do it that way without getting rid of the Morrison exception. But you could at least say this is a principal officer, so he needs to be appointed by the prosecutor.
I'm trying very hard to get that. I filed an amicus brief in the 11th Circuit about a week or 2 ago on this exact point. The wrinkle here, and I'll just in candor, Morrison was about a statute that doesn't exist anymore. It was the independent counsel statute that lapsed in 1999. What we currently have is a series of regulations that are imposed on the executive branch upon itself. Right? With the independent counsel, you have the courts appointing the prosecutor. Here it's the AG appointing it. So I would agree, I'll say this out loud, that the current regulations are an improvement upon the independent counsel, but they're still bad. And I think that they're unconstitutional under Morrison, with Scalia dissent in Morrison. I think the more likely path is that if, well, a lot happens in the election. If Trump wins, I think there's a good chance the regs are just repealed. Right? You can't, the president can't repeal a statute, he can repeal regs. I think he can direct his attorney general at the appropriate time to repeal the regs. By the way, Trump should wait, by the way, for the 11th Circuit to rule. I don't think he should do it beforehand. I think just let's see what the courts do. It might give you some information. But I think the special counsel will lose his job at some point. If Trump loses, in some regards, that sends the issue to the Supreme Court. People say, oh no, you're going to kill the special counsel. There are many ways the court can take it. They don't have to overrule Morrison. But Josh Blackman over here, you know what I did? So I was arguing this amicus in Judge Cannon's court. And the very last thing I said, Mr. Blackman, you're done. I was like, Judge, just one more thing. Like Steve Jobs, just one more thing. And I said, Your Honor, I realize I'm an amicus, but I would like to preserve the issue of whether Morrison v. Olson should be overruled. Did you know amicus can do that? Neither did I. But it can be done. So Mapp v. Ohio, you know the case Mapp v. Ohio? Primpro exclusionary rule? Overruled Wolf v. Colorado? Who asked to overrule Wolf v. Colorado? It was not Dollar Mapp, it was the ACLU. And the court has a footnote saying, amicus asked to overrule precedent, we're going to do it. So, damn it, I'm going to be at the ACLU. So I asked the District Court in Florida to just preserve the issue to overrule Morrison. And oh man, the DOJ lawyer almost lost his mind. He says, he was behind me, but his face turned white. And he said, did Mr. Blackman just ask this court to overrule Morrison? No, that's not what I asked, you heard me, right? I asked to preserve the issue. And I put an amicus for the 11th Circuit, and there's a section saying, preserving Morrison be overruled. So if the court does overrule Morrison, you're welcome. That's Maui would say. What can I say? All right. You know, if young kids, Moana, nothing? Okay, thank you. My girls love that movie. Yeah.
Just a broader question on the special prosecutors. It seems like a weird position that was sort of come up with whole cloth because of a couple presidential scandals. But I've always thought it's weird how it's in the DOJ, in the executive branch. At one point, there was, during Teapot Dome, they approved it in the Senate, and it was Congress that originally brought the special prosecutor. Can you sort of give yourself...
Where did you hear about that? I've written about that.
Wikipedia.
All right, do not trust Wikipedia's wrong on this one. By the way, so
Okay.
I wrote, so the amicus brief I filed in the 11th Circuit goes through all of the major special prosecutors in American history, all of them. So there was one during President Buchanan's administration. There was the Jefferson Davis prosecution in the Johnson administration. There was a so-called whiskey ring scandal during the Grant administration. During President Garfield, didn't live very long. He had the Star Route scandal. President Roosevelt had a couple scandals, one involving the Postal Service, one involving land fraud in Oregon, and then there was Teapot Dome during Calvin Coolidge, there was a scandal during Truman. Those are the 6 or 7, how you count. What's unique about the Coolidge one is that Congress passed a statute, as the gentleman said. And the statute said we're going to have these special prosecutor positions, which will be nominated by the president and confirmed by the Senate. Imagine that, just like a U.S. attorney. That precedent does not help Jack Smith at all. But what's unique about this statute, though, it actually orders the president to nominate special counsel. Rob, could Congress order the president to nominate someone?
No.
I don't think so. So
Clearly not.
what's interesting is the statute also gave almost complete independence to the prosecutor. The budget was basically set by Congress. The president didn't even set the budget. It's also a problem. And if you actually, there's a CRS report in this, the Congressional Research Service, where it says he has total independence from the president. It didn't actually say removal insulation, but I think there was removal insulation. This was also 2 years before Meyer against the United States, the famous postmaster case. So this statute is unconstitutional like 3 or 4 different ways. But it's a precedent that at least shows that you can nominate with Senate advice and consent, not this internal stuff. So I think that's a useful precedent for us, but Wikipedia is wrong in a couple of regards. Yeah, go read our 11th Circuit brief on all the details of this, everything, all the history. It's good stuff. You would think Jack Smith would have read this history, but he didn't. Maybe
So
he did, I
if
don't know.
Congress tried to appoint a special counsel now, what would happen?
If Congress directed the president to appoint one,
Well, now if they created their own, because obviously the president wouldn't.
outside the
comply.
executive branch?
Yeah.
Well, like the old independent counsel statute. Oh, I think that's unconstitutional.
It-
I mean,
it clearly is.
the way it worked, and the gentleman mentioned Morrison a moment ago, you had a division of judges on the D.C. Circuit appointing a prosecutor. And William Rehnquist, bless his soul, said, okay, that's fine, yeah, federal judges can appoint prosecutors. Whoa, right? Scalia said this is a separation of powers. This wolf comes as a wolf. By the way, Judge Lawrence Silverman, an American hero, and I miss him dearly, his dissent in Ray Sealed case should be read by every law student. Scalia got it from Silverman. If you want to see where Scalia, the pros, but Silverman held the logic there.
So Congress could not appoint a prosecutor that would actually have law enforcement authority, but Congress could appoint some sort of prosecutor who could investigate and turn findings over to Congress to engage in congressional oversight investigations. True?
Yes, and the power of the congressional subpoena is also tricky because can one person exercise it, or must it come from a vote of the House? It's actually that's not an easy question.
I mean, I'm not a big fan of Congress.
Period.
Probably true, but they shouldn't be getting in the law enforcement business.
It's risky because what do you do with a report, right? At least with a criminal indictment, in theory, you can have a trial, you can adjudicate who's innocent, who's guilty, right? But with a report, it just sort of sits there, and the accused can't really rebut it. That's why the J6 committee. I mean, there's not like a minority report. They only had people on it to agree. What other questions we have? Yes, sir.
When you were listing the majority in the case, you listed all of their executive experience, but Justice Kagan has a lot of executive experience.
She does.
And
She does.
Do you have any thoughts on, she did not write in this case when she joined the Sotomayor dissent? Is there any thoughts on why she's the one former solicitor?
So look,
General
if
didn't join?
any president can understand what harassment is in the executive branch, it's Elena Kagan. I don't think she can hold her nose in this one writing something. I think she just joined the Jackson and Sotomayor ones. I think she lived through Clinton against Jones. She lived through that. She knows what's going on here. But she can go on the stump and say how awful this is, immunity and so on. I mean, Rob, she's an executive branch lawyer. You're a White House lawyer. How do you think she thought about this one?
Oh, I'm so surprised she didn't join the majority.
I mean, look, so he's being sarcastic. There's reporting saying that the liberals tried to broker a compromise. So maybe Kagan initially tried to say, look, I will lend my vote to the majority if you guys water this down a lot. And Roberts like, I don't need you. I don't need your vote. And for once, Roberts actually held the line. He usually squishes in every case. He was not going to squish. I mean, look, he thought this was a case for the ages. This will be a case that people will study. He's wrong about that. People won't care about it. But he thought this will be one that will protect presidents for a long way in my lifetime. By the way, he wants to be, if he's Chief Justice for another 15 or 20 years, he'll be John Marshall's record. That's going to be his goal. He wants to be John Marshall's Chief Justice. He'll be 84 when he finishes, if memory serves.
Is that right?
Yeah. He was appointed in 2006, no, 2005, so he's up and coming 20 years. He was appointed right when I started law school. I started in the fall of 2006, which was shortly after Roberts and Alito joined the court. I'm dating myself. That was a very different time.
So since you brought up the chief and the dissents, another thing I took away from the opinion was his uncharacteristic aggression towards the dissent.
Yeah.
Starts near the end of the opinion. I mean, he opens his response with the line, "As for the dissents, they strike a tone of chilling doom that is wholly disproportionate to what the court actually does today." Okay?
Yeah.
What do you think is going on with
I
a little
think
bit of chippiness here in the...
I think there's a lot of infighting on the court now. I was at the court yesterday morning. There wasn't a lot of banter. They didn't seem very, chipper, to use Rob's words. I think Roberts was very disappointed that the liberals he thought this would be a clean opinion that everyone could join, and I think he was kind of annoyed they didn't. I think a lot of the rhetoric in the dissent was sort of doomsday, the SEAL Team 6 example, right? That the president orders SEAL Team 6 to assassinate his rival. By the way, the president has duty to take care of the laws are faithfully executed. By whom? His subordinates. If the president issues an order to SEAL Team 6, okay, go murder Kamala Harris, right? Are they going to obey that order? No, they're going to either resign or call them. I don't really call someone, but they're going to resign, call the New York Times, the Washington Post, someone, right? The president can't do much damage by himself, right? He can only do something subordinates go. So even if President Trump has immunity himself, his subordinates do not have immunity. They'll be held liable. So justice will be served even if the guy on the top is not held accountable. So I think a lot of these sort of doomsday predictions are I think, really hyperbole. Yes, in the back.
First of all, thank you for coming and speaking.
Thank you.
It's very insightful. I didn't know how long this was discussing. Regarding that point that you just brought up, though, it seems that's contingent upon the assumption that the subordinates also have a clear understanding and respect for the rule of law, and thus that if they do disobey it, the president won't exercise pardon as a result.
No, that's absolutely a fair point. So there are two things to recognize, right? Number one, if indeed SEAL Team 6 murders the vice president or someone else, that is a public act which all will be aware of. And there are political costs issuing pardons. I mean, Rob was a White House lawyer. Issuing a pardon has a political cost. So even if you have rogue mercenaries working the executive branch, which they might do that, and they decide to go assassinate Kamala Harris, and the president issues a pardon, that still will weigh heavily on his reputation. I think, let me take a step back. The check on the executive is not going to be the courts. It's going to be political opinion, right? I think that's the greatest check, and trying to use lawfare to try to win away the president's powers, I think ultimately doesn't succeed. Please.
So if I may follow up.
Please.
Let's say Joe Biden were to have Donald Trump Epstein or something like that.
Epstein, just
Have Donald Trump
a noose.
SEAL Team 6 to shoot Donald Trump and
Make it look like an accident.
something that they do in next. Thus, in that case, the mindset is I'm leaving office, I don't need to worry about political capital. Do you think that political cost check still applies?
I mean, I love law school hypotheticals because they're kind of awesome. So again, just to set up if you didn't hear it, Biden orders that Trump gets Epstein. That is, make it look like a suicide. Is that what you're just getting at?
You know what, for simplicity, let's say your SEAL Team 6, that's SEAL Team 6 to shoot.
Is Secret Service going to invade us? Do they even do their jobs wrong? I don't even know. They can't even stop a bullet. What are they going to stop? Yeah. So I guess look, if the president orders a secret assassination mission of his rival that no one knows about, I think we're beyond the realm of what immunity is. I think at this point we're in banana republic land. I mean I don't want to fight your hypothetical, but if that's really what's going on, that the sitting president decides to quietly set up stage a suicide attempt of his rival, and he gets away with it, I think as a country we're in pretty rough shape. But let me give you an actual hypothetical for real, right? Let's say we have an election in 4 weeks, right? And let's say that there's litigation in the courts. Here's what Biden knows. If Trump wins, it's a good chance Biden gets indicted for something. They'll find something. And there's a good chance Hunter gets superseding indictments for a lot more. So even if the father pardons his son will be in jail the rest of his life. Okay? Trump realized that if he loses, he's probably going to go to jail. He'll spend the rest of his natural life in jail. So here's the deal, right? Let's make a deal. Biden says, I'll tell you what, You drop your election litigation, I will give you a complete pardon for everything. That's the deal. Kamala becomes president, you will not go to jail. I'll pardon anyone in your orbit you want. Is that a bribe? Let that one spin for a bit. So that's a kind of like my West Wing theory of like how if Biden actually, rather than assassinating Trump, Epsteining him, if you will, God Lord help us, he does a Jack Welch, let's make a deal, right? Anyway, maybe one more question, and we're running low on time. Rob, anything else? All right, thank you so much, George Mason. Always a pleasure to be back here. Thank you.